Hello, you are listening to the University of East Anglia Law School podcast series. In this special episode, we present the Earlham Lecture 2024 of Digital Assets and Sausages, Confessions of a Law Commissioner. This episode is presented by special guest speaker, Professor Sarah Green, Law Commissioner for Commercial and Common Law in England and Wales. This talk was recorded live on the 30th of April 2024.
What I intend to talk about in this lecture is a little bit about, as you can see from that, I was just thinking, looking at this picture, I've lost that necklace. I love that necklace. I haven't seen it since that picture was taken. A little bit about how the Law Commission works, because before I worked there, I didn't realise, and it is germane to the title of this lecture, I didn't actually realise, despite having worked in academia and worked with lawyers and worked with judges for many years, I didn't actually realise what the law reform and legislative process was like on the ground. And I think it is incredibly interesting for anybody really, but particularly for law students, because knowing how the law gets to where it is now is, I think, a very valuable piece of knowledge in understanding the sort of full impact and understanding the history of that piece of legislation. I think tells you a lot about questions you might have about that final form. And that explains the reference to sausages. So you do have a quote up there on the slide. There are various versions of this quotation. And the first one that I was aware of, they're pretty much the same thing. And of course, they express the same sentiment. But this was by so when was it? It was the same century, and it was a lawyer poet called John Godfrey Saxe who said that laws like sausages cease to inspire respect in proportion as we know how they are made. So the point is the same, that maybe the less you know about how these laws come into being, the purer perspective you can have on those laws themselves. But as I said, I think there is a lot to be said for understanding quite how that process works. So I will say, partly through the medium of some of the reforms that I've looked at as Law Commissioner, I will say a bit about how the Law Commission works and how it really differs quite dramatically from what I thought of the Law Commission and the life of a Law Commissioner when I was a law student, reading final reports and consultation papers and reform proposals, and not really understanding the difference between all of those things, despite the enormous clues in the names of each of them. So what I thought I would do, just to start off with, to give you the picture before I go on to the reforms that I'm going to talk about, and just as a sort of potential spoiler alert, what I'm going to focus on today out of that long list of things that I've thought about over my scarily long career. I still feel like I've been doing it for only about 2 years, but it's a very long time, is the technological reform. So I'm going to talk about electronic trade documents, and I know that sounds absolutely not exciting at all, but I will try and explain why actually it is very significant and it is exciting. Digital assets, cryptocurrencies, tokenization, I'm going to talk about that, why it's important, why it's such a problem for the law, and why I, as Law Commissioner, ended up looking at it. So, but it is important, as I said, that the process is germane to understanding why those reforms look the way that they do. We made law reform proposals about digital assets, how the law should treat things like NFTs and cryptocurrencies and electronic documents. We made those last July. And the Electronic Trade Documents Act came into force in September 2023. So it's all fairly recent. So what did I think as a law commissioner? What did I think I'd be doing? Well, quite honestly, when I pictured law commissioners when I was a law student, I imagined that it would be a very sort of leisurely start to the day, reading the newspapers, familiarising myself with everything that's going on in the world, the pressure points, the difficulties, the problems, and then having a nice leisurely think about what I might want to do to resolve some of those problems. And then, I don't know, have a stroll around St James's Park, which is where the Law Commission offices are, or at least close to that, pondering some great legal question about, for instance, how do the French make contracts without consideration? You know, how on earth does that happen? And then maybe having lunch with a colleague or a judge and talking about the finer points of the primary secondary victim distinction in psychiatric injury and negligence and what we could do about that. And it would all be very based on what I thought was interesting, what I had discovered through my studies and research would be, an important thing, an important way for the law to develop and direction to go in. It is not quite like that. So a typical day as a law commissioner looks a little bit more like being a very early customer of the Circle Line and sitting there with increasing panic, listening to announcements as to why we've been stuck in this tunnel for 25 minutes and why I am very unlikely to make the meeting that I'm supposed to be having with policy officials. Said meeting has taken 3 months to get in the diary. It's only 20 minutes long. It has been made very clear to me that said policy officials are not that enthusiastic about meeting me, and that will be my only chance. Get off the tube, run to Portcullis House, which is only about 5 minutes away, but by this point, I'm quite stressed. I don't want to miss this meeting. I get there, I'm very sweaty, I've got a shiny face, my fringe is plastered to my face, and I don't look anything at all like somebody that parliamentary security wants to admit to the building. And yet I am adamant that I want to be admitted to the building. They don't let me in, and the policy officials have cancelled the meeting anyway. They're very sorry, but they haven't got time to see a law commissioner when there are many other things going on. So I will come back to that. It is a job that's difficult in ways that I wasn't expecting. I thought I would just be dealing with fantastically thorny, interesting legal problems. And there is a bit more to it than that. But before I come back to the sausages, to the grist and the sawdust of the legislative process, there are a lot of positive things I want to say about the Law Commission. And again, I think this is really important if you understand how the Law Commission laws come into being. So when I finally get to the office after this cancelled meeting, this is the good part, because I encounter, well, the number of people in the office has changed quite a lot since COVID, but the Law Commission is about 70 people strong. And everybody who works at the Law Commission, from research assistants who tend to come to us for a year straight after their degree, to lawyers who run a research project, to the team manager who oversees the projects in a particular team. There are 4 teams. And then you've got the commissioner who oversees all of those projects. And what I will say about these people is that they're all incredible. They are amazing people. The Law Commission is a very lean organisation, I think. And the other thing that I imagined when I was sort of picturing this Instagram life of a law commissioner was that we'd be in oak-panelled rooms and that we would have, these beautifully appointed bookcases. And, it's not like that either. We're in a building that if you didn't know was a government building, you wouldn't have to be told. And there is, and I am not joking on this, there is a stapler in the office that everybody wants because it works. So there are 70 people, and this stapler has disrupted friendships, it's delayed projects. Everybody wants the stapler, and they will be reduced to pathetic creatures trying to keep possession of it. So we're a very, very lean organisation, and the people that work for us have to put a huge amount of work in. They do that time and time again. I'm constantly amazed by how much Law Commission staff get done. They sometimes devote all of their waking hours to a project and to good effect. So that is definitely the upside of working there. If anybody is thinking of being a research assistant in the more immediate future or in the medium-term future as a lawyer at the Law Commission, you will not regret it. It's also not a very hierarchical organisation, and the really good thing, I think, about working there as a research assistant is that you are involved from day one, absolutely and totally in the projects that we do. You're not just taking minutes, you're not just doing photocopying, you do have to do that, but you are a very valued part of meetings. You meet with stakeholders, you are there, you are encouraged to speak, to ask questions, to give your views. You are definitely not there as an observer. And I think that's why research assistants really enjoy their time with us, and they really value it, and future employers really value it as well, because they know that these young people have been, dropped in at the deep end, really. And also they get to see this parliamentary process, and they come to sit in Parliament and see the commissioners give evidence, and they write briefings for that. And they're, as I said, absolutely involved from day one. So that's all fantastic. That's not the sausages bit. Just gonna certainly look at my watch, see how long I've got. Right. So what else happens then with a law commission project? So there's 4 teams. So there's commercial and common law, there's criminal law. You've probably heard a bit more. They tend to have more headline grabbing projects. Hate crime, online harms. These are the recent ones they've done. I'm sure you've seen those in the press recently. There's a property, family and trust team. Again, they have fairly high profile projects. They've looked at weddings, surrogacy. And then there's public law and law in Wales, because we are the Law Commission of England and Wales, not the UK, even though that's what we're often referred to. I'm sure to the dismay of my colleagues at the Scottish Law Commission, who have their own thing going on. So there's those 4 teams, and we're a very consultative body. There are at least a couple of people in this room who have very helpfully contributed to my projects in the past. Genuine consultation. So we speak to stakeholders, we'll listen to anybody, and I really do mean that. Anybody who wants to talk to us, if we say we're thinking of looking at a particular area of law, if you have an interest in it, it doesn't matter if you're a lawyer, it doesn't matter if you don't know anything about it. If you're involved with it and you have a view on it, we will listen to you. And that's how the process works. We mesh that with the research that happens in-house, and then we come up with proposals, and we consult on those proposals. And then we often, and we actually do this very frequently, we change those proposals when consultees tell us that for various reasons they won't work. So that's the good side of the sausages bit, because it means that if I was just an academic sitting in an oak panelled room in a very ivory tower way saying, this is what I think about digital assets and how they should be treated, that'd be fine as far as I was concerned. But of course, if I then make law reform suggestions that don't work for the people who are actually subject to that law, total waste of time and money. So this is a misconception, I think, and it might be because historically this is how the Law Commission worked, but the reforms that we make as a team are not my ideas. I mean, they might start off as my ideas because there needs to be some form of catalyst, but if consultees disagree with those ideas, we change them. So we are a genuinely consultative body. We also have, so this is when I'm going to start talking about a particular example, which, as I've said, is the Electronic Trade Documents Act. And again, I do acknowledge that the name of that is not particularly invigorating for most people. But I will hopefully explain why it's a very important piece of legislation. But this was the first piece of legislation that I saw through from start to finish, which is why I'm going to use it to illustrate for you how this legislative process works for the Law Commission. So what we also have, and what my team tends to take advantage of, is a parliamentary procedure called the special procedure, which is specific to Law Commission bills. And the thing that's good about it is that it is expedited. And because of that, we can only use it for what are called non-controversial bills. So the things I've just talked about that my colleagues in crime do, like hate crime, online harms, that was never going to work in the special procedure. It is for non-politically controversial bills. And it won't surprise you to learn, or maybe it will, that the Electronic Trade Documents Bill was not a controversial piece of legislation. Nobody really objected to it. I mean, I think that maybe paper manufacturers might not have been too happy with it, but they weren't saying anything, so we went ahead. And the point about the special procedure is most of the debate happens in the House of Lords, which means, whatever your feelings about having an unelected chamber, it means that most of the debate is intellectual rather than political. And I'm sure you can see why that's helpful for something where there aren't really any political losers. And so I get grilled, other witnesses get grilled by the House of Lords in a chamber, in a committee. Most of the work and any suggestions that are made or any changes that are proposed happen in that arena. And of course, then it is then quite divorced from any political, winds and political forces. Not that I don't think there would have been many here anyway, because your average constituent doesn't really care about whether you can use a document on a distributed ledger as a bill of lading. It's not usually top of most people's lists. So what happens is we have this procedure, so where we get grilled about our law reform by the House of Lords. And then, and this is the thing that I think is really interesting, and I didn't really understand before I did this job. The House of Lords does kind of what we do in the consultative process. It opens a call for evidence. It says this is the legislation that we're thinking of enacting because we've produced a draft bill. We have our own in-house, what are called parliamentary counsel. Again, I didn't realise that this is what happened. And they are people highly, highly trained, geniuses, every one of them that I've encountered, who are trained to draft statutes. And you might think, oh, well, that must be hard. It is incredibly hard. And I always used to think I could do it. No way could I do it. I go to parliamentary counsel and say, this is what I want the Act to do. And they present me with this. After a while, they present me with this draft bill. And I first think, gosh, is that really what I asked you for? And then they'll explain it to me. And then I'll realise why if they did what I wanted them to do, I would have broken commercial law completely and it would have been catastrophic. So we present this to Parliament. And then the House of Lords opens this call for evidence and says, anyone who doesn't agree or thinks this should be different, tell us. I mean, it's like a sort of Love Island for legal geeks. You can basically just, phone in with your with your feelings and objections, which to me I found very difficult because this bill, so this 2023 bill, had been something that as an academic I'd written about for best part of 2 decades. I mean, as I said, it wasn't just my views, but the idea of making sure that the law could accommodate electronic documents was something that I'd been working on for a while. And so seeing this process in the House of Lords where people could just say, I mean, most of them were obviously specialists and lawyers and people who knew their stuff, but you're still opening up to people who say, oh, well, I wouldn't have drafted it like this. And I think, well, I wouldn't have drafted it like that either, but that's what parliamentary counsel did. And I now understand why that's actually much better than what I would have come up with. So it's the democratic process, of course, that's how it has to happen. But it is very difficult for the author. It's almost as difficult as listening to somebody criticise my own children. And so that's what happens. And then they listen to evidence from all of us. And then if you're lucky, or if you've done it properly, it becomes law. And that's what happened in this case, thankfully, although it did take a while. I think I'm the only law commissioner to have a bill that was trying to get through Parliament while there were 2 monarchs, and every time we change monarchs, Parliament dissolves, so you lose it. You're in this process, and then 2 monarchs, 3 prime ministers, and 4 Lord Chancellors in the space of one bill's passage, and so that is definitely part of the sawdust and gristle of the sausages part of the process. So it is, there are ups and downs, as you can see. It is we owe a huge amount to consultees. As I said, we get to these proposals by virtue of a long and detailed discussion with people who absolutely know what they're doing because they use these laws every day, either as end users or their legal advisors. And we also, and I will come back to this when I talk about the substantive topics, we also have a very close relationship, certainly in my team, with the judiciary. And we hold judicial roundtables. So we have roundtables that obviously have judges there, and we test law reform proposals with judges and ask them for their honest opinions. And of course, that has been incredibly useful to us, because some of what we say is we don't think this needs statutory reform. So not all of the reform proposals that we make end up in legislation, and that's deliberately so. And so what we don't want to do is make it look as if we're passing the buck to the judges and then just, avoiding the work ourselves, because that's definitely not the intention. So we've had a few round tables with judges where we test, as I said, what we're going to do with them, and they tell us whether they think it's a good idea or not. With my projects, those judicial roundtables have been particularly interesting because the judges who, obviously we don't make them mandatory, and the judges who turn up to those roundtables are either judges who are very technologically literate and very technologically interested and engaged, and in some cases know a huge amount about the technology, Some of the judges who turn up for exactly the other reason, that they don't know much about the technology and they want to know about the technology. And of course, they're going to have to, at some point, deal with a case that requires them to know about it. And then, of course, as with any roundtable, really, there are also some skeptics of the technology and of having to make any legal change. So those were very, very interesting and productive roundtables. And it's a real test. It kind of does feel like the ultimate test, really, of what you're doing as a law commissioner when you're actually, it's all very well. I remember as an academic saying, oh, this should be something that's developed through the common law. We can leave this to the common law. And do think that's a very important means of developing the law. But of course, when you're actually sat in front of the people who you're expecting to do this development, and they are there to ask you questions about it, it does feel a bit more of an ask to justify that position. So that's the process. As I said, we can't always use the special procedure. My colleagues in crime and family law, where it is often very politically contentious and controversial, they don't get to use that procedure, so their bills have to go through the houses in the same way that you're already familiar with. Spend a lot of time in the Commons, and that's when, well, I'm sure you're all aware of the online harms that's been discussed a huge amount in the press, and it certainly was in the House of Commons. So there are very different pressures. If I was a law commissioner from a different team, you'd be having quite a different talk now, because their difficulty is, I think, obvious. They deal with very emotive subjects. I mean, they have a very difficult time on, and they're not really on social media, because you can imagine that they get very difficult responses, I think it's fair to say, because they deal with very emotive, very politically sensitive subjects. I sort of have the opposite problem in that, and I'm grateful for that, I should say, this is certainly not a complaint, but I would say my issue as commercial and common law commissioner is, and I do have a social media presence because I'm trying to do this, is that my projects don't tend to be headline grabbing, even though, and I know I would say this, but they are very, very important commercially and economically, but they just, until you describe them, and maybe even after that, they're not the sort of thing that is going to they're not shiny things, right? This is what we say when we're trying to sell things to government. They're not shiny things that the government can say, yeah, I can put that on the front of, or, we can sort of make sure that ends up on the front of a newspaper and that'll look really good for us. I mean, I do think they're shiny underneath, but you have to explain why the projects that I deal with about digital assets and electronic trade documents and arbitration, you have to explain why they're shiny. They're not obviously shiny. And so when I do finally get these meetings with policy officials, the thing I wasn't expecting about my job is that I have to, we're an independent body. We're sort of intellectually independent. And when we do projects, we are absolutely independent in that we do not make recommendations that government has asked us to make. That's very important, very, very important. But we rely on government funding, and government will only fund us for a project if it has a serious intention of taking it forward. So basically, a lot of my job involves selling these projects to government, to policy advisors who have 20 minutes. They're very busy people. They tend not to be lawyers. And when you've got 20 minutes to explain to a non-lawyer, I often think it's like getting a first-year student from day one in October to LLM level in 20 minutes on a particular topic, because they're very busy. They're usually sort of looking at their watch for most of the time you're talking to them. And I have to explain things like, why do two words in a statute that was passed in 1882, so the Bills of Exchange Act 1882, that's basically what the Electronic Documents Act changes, there's two words in that are causing a huge amount of economic turmoil in 2023. And they really were. But I have to explain why that is in 20 minutes to somebody who isn't even a lawyer, doesn't even know or care what the Bills of Exchange Act does. And of course, as soon as you say Bills of Exchange Act 1882, everyone's like, we're done here. When you attach figures to it, sometimes helps. So when I pointed out that it's worth about 25 billion to the UK economy, they're like, oh, what did you say it was again? So you just have to learn to, and they're not natural lawyer skills. They certainly weren't my natural skills. I never considered myself to be a salesperson. But that is a huge part of being a law commissioner, is explaining to government very quickly and succinctly, and usually linking it to money or other shiny things that means that they want to give you the money to do it. So, to turn to the substance then, I think I have been very lucky as being law commissioner in the period that I have, because I have overseen what I consider to be some really, really fascinating subjects that were quite dear to my heart. And I think also, as I've said several times, a lot more interesting than they sound on the surface. And why is that? Because, well, I mean, I think one of the reasons that I got the job was, you heard David say at the start that I used to be a software developer a very, very long time ago. But what that meant was that when I went back to law, so I used to build websites and things. And when I went back to law, I thought, a lot of this stuff that I've just built and we've been working on, that's going to cause a lot of problems for law, because the common law, and English common law particularly, is hugely important. I'm sure you will know this, is hugely important as a global export. About 80% of international commercial transactions are subject to English law. Parties really like using English commercial law because it is certain, because it is predictable, because we have, very trusted courts, we have excellent lawyers. It is a huge export. That's another point that I make to government a lot, because not all of them understands what a huge and, important thing that this that our law is. And I think what's really been interesting and important during my time is trying to make sure that English law remains in that pole position, or at least preeminent position. And it does have a reputation for certainty, for being predictable, for not changing with the wind, particularly contract law, right? So contract law, I often refer to as the cockroach of the common law, that, economic and social changes come and go, and contract law remains exactly as it was. So I've had to tread quite a fine line between maintaining that reputation, but also making sure that it is fit for purpose in a technological age. And the problem is that until very recently, and to some extent still, it isn't that fit for purpose in the technological age. Don't worry, I'm not going to go into huge detail about contract law and property law, but I think it is worth pointing out in technological terms what the issues were and what really we have had to do about that. And there are other jurisdictions around the world. We're all grappling with the same issues, and we have worked together to a large extent. We have sat on, sort of working groups, and we all know what each other's doing. And since the 2023 Act, other jurisdictions have asked us, how did you do that? We'd quite like to do the same thing. And actually, that's great, because as an international commercial thing, it doesn't really work that well unless everybody's doing it. Although there is something in the Act to cater for that. So what is it about? I mean, it's really about the fact that this is why I think I've been law commissioner at such a good time. It's a really interesting time technologically, because until fairly recently, you couldn't actually emulate in technological terms conventional things. They weren't ever quite the same. And the problem that you encountered if you tried to do so was, essentially, I think it all comes down to the double spend problem. So if you have something in technological form, so until very recently, so imagine sort of a pre-Bitcoin time. So we don't have distributed ledgers. And actually, if you tried to do certain things in technological form, the issue was that they're so easily duplicable. I've made loads of words up during these projects. That they're no good, because you can double spend them. I could send some electronic money to A and then send exactly the same money to B. I know that's a huge simplification, but given the interest of time, what I'm trying to say is, with distributed ledger technology and with blockchains, what we have really been able to do as a society is emulate conventional things in technological form. So take NFTs. Now, at the start of this project, NFTs were a big thing. I don't know if you remember the yachts and the, things that people spent 63 million, and one of them was. So, millions and millions of pounds on an NFT. So basically a sort of first edition Dickens, but in technological form. And it was unique, and it was completely exclusively possessible, and it was completely, perfectly transferable and totally divestable. I'll come back to those things in a minute. But basically it emulated a real life conventional thing that I could hold and buy and pass on and lose and break and burn and all the things that before you couldn't really do in technological terms, because there was always some sort of form of backup to it. So several of the projects that I was engaged with were concerned with this question: what does the law do when technology can all of a sudden replicate what we've always done conventionally, and yet the law isn't there? The law hasn't caught up. So to go back to the Bills of Exchange Act, there are hugely important documents in international trade. I'm not going to spend very long on this because it's really not that interesting in its own right, well, except to me and maybe 3 or 4 other people in the world. But you need, for these documents of title in commercial law to function, they need to be able to have certain properties. So if I have a bill of lading which represents 500 tons of rice on a particular ship, it's very important to me that that bill of lading is singular, that I have the only possession of it, that whilst I have that bill of lading, it is mine and so is the rice. That's the important thing. That document of title has to have that characteristic, that when I pass it on, say to David, I no longer have it, he also has the rice. Until very recently, as I said, we couldn't replicate that in technological form. I could just keep, like a Word document, I'll send it to David, I still keep one, I can replicate it, I can send it off to 100,000 people. That is no good commercially, absolutely no good at all, because it's the singularity of that thing that matters. Technology now allows us to do that in documentary form, but the law didn't keep up with that. So the Bills of Exchange Act says this document has to be delivered and it has to be possessed. And we have common law authority that tells us that you cannot possess, well, I'll stick to that. You cannot possess a digital thing, or you can't possess an intangible thing. The law regards digital things as intangible. I actually don't think that's true, but I also don't think it necessarily matters. I think there are a lot of people who don't think that digital things are intangible. Exactly. They have a physical presence somewhere, albeit at a microscopic level, which is why your phone and your laptop, of course, does not have infinite storage. The software takes up space at some level. But anyway, as I said, I don't think that really matters. What my projects have been concerned with, this is really what the Electronic Documents Act does and what our reforms with digital assets do, is say, forget about tangibility. That's what's causing all the problems. That is what's preventing. So when it doesn't sound very interesting, what I say to people is, well, do you realize that so I'm going to rewind to the start of the project when NFTs were still a big thing. Everyone was talking about NFTs. They're still used now, but in a more commercially sensible way. They are used to represent other things. But when they were still, I'm going to buy this Bored Ape for, 3 million or whatever. And if you say to people, well, when you invest in those things, do you realize that actually, even if you spend 3 million on it, you might not have property rights in it. You might not own it. And people are like, what? How can that be? Well, that can be because the law hasn't kept up and regards that thing as intangible and regards it, therefore, as not being capable of being the object of property rights, which means, all sounds very boring and lawyerly like lawyer's law, and it is, but it has very important practical implications. And one of those very important practical implications is that you've spent 3 million on it. Law doesn't care. If somebody takes it from you, somebody hacks, however, depends on the technology, but however they deprive you of its possession. If they nick your car, you can sue them. You get the market value of your car, pretty obvious, everybody presumes that. If you do it with an NFT that costs you millions of pounds, the law is still like, do you have property rights in it? Not really sure, it's intangible, don't know, don't think you can sue for it actually, sorry. And that's massive. That is massive. People just presume these things are so fundamental and rudimentary that people think, well, if I spend 3 million on it, of course it's mine. And of course the law will protect me if something goes wrong. But that is not strictly true. And certainly before we did our digital assets work, that was not clear at all. I mean, people just didn't realize that, and why would they? So this is why the market for these assets is still relatively buoyant in certain patches. We also, of course, hear about the nefarious stuff. We hear about FTX. We hear about all the disasters. We hear about crypto and pyramid schemes. And of course, that is all very problematic, but it's even more problematic if we don't have these underlying law reforms and recognition that tells us how the law should treat these things. So I quite often say to people, I'm not, the point of our projects is not to say, oh, you should all go out and invest in crypto. I'm not an apologist for any of this, but I just think that at a very basic level, it's super, super important that the law knows how to deal with these new technologies. And until very recently, and to some extent, it still does not, because it cannot cope with this thing being obviously at this microscopic level, that is not a conventional thing like a pen or a watch or a laptop. Historically, what the law did, of course, was distinguish between those conventional things, horses, bags of gold, and computers. And then things that were purely intangible, debts, for instance. Debts is the obvious one. So a debt is purely intangible. It only exists insofar as there are people to claim it and a legal system to recognize it. There is no thing in the world that is a debt. It's purely ethereal. Very important commercially, but purely ethereal. And it's not like a horse or a bag of gold that exists in the world, regardless of whether anyone lays a claim to it and regardless of whether a legal system recognizes it. I mean, obviously it helps if it does, but it's still there physically. Where do you put digital asset? Is it like a horse or a bag of gold? Or is it like a debt and purely ethereal? Well, that was one of the big questions in our digital assets project. And we ultimately came down to a conclusion, which is that it's not really either. Personally, I think it's more like a horse or a bag of gold, because as I've already said, I think it does have a physical existence. The thing about having an NFT is that it does exist in the world, whether you lay claim to it or not, and whether a legal system recognizes it or not. It's still there on your computer. So I think it's a little bit closer to things in possession. But it doesn't perform in quite the same way. So if I have a pen and I pass it to somebody else, that pen goes unchanged from me to that person. They get exactly the same pen that left my hand. And that's a very straightforward, legally analysed situation. But of course, a digital asset, or most digital assets, won't do that. What leaves me and goes to them is something that's slightly different. There are different theories, and it depends on the particular technological platform. But a lot of the time what will happen is what I have is extinguished and then it's recreated, say, in the wallet of someone else. So there were reasons. I mean, I'm trying now to summarize about 1,500 pages of analysis. But basically what we said was these digital assets sort of sit in the middle because they're not quite one or the other. And basically, the law just needs to realize that. And this is one of the things that we spoke to judges about. Okay. This is one of the things that we spoke to judges about, because we said this is a job for the common law. These things are very different. I mean, I'm already talking to you about NFTs and they feel slightly historical, even though the project was only 3 years long. So what we said was it's really important for the law to develop as these things develop. If we put it in a statute, we had to do it with the Electronic Trade Documents Act because of the Bills of Exchange Act. And as I'm sure you all know, common law cannot change a statutory position. You need a statute to do it. But with digital assets, with what I'm talking about now, about can you own an intangible thing, that's all common law rules, mostly. In the main run of things, that's all common law rules. So we said, actually, the common law is best placed to do this, because if we put it in a statute, not only would that be very difficult, but it wouldn't necessarily be helpful, because these digital assets are going to change really quickly. The technology is going to move on. So what we really think is best is we provide a framework for the common law. This is what we presented to the judges, and say, this is how you should develop the common law. These are the characteristics that you should look for in a digital asset. And then you can recognize, or you should recognize, that you should treat it in the same way as a bag of gold. So that if somebody does steal my NFT, or I suppose if we're being strictly civil law about it, if somebody converts my NFT, they prevent me from having access to it, either because they've hacked my wallet or because maybe they're the developer and they haven't done the development properly and I lose it, then I should have legal redress. Why should I not have legal redress for that? Just simply because the law has not kept up with a technological understanding of property. So that's what we recommended. So if we try and put that in a statute and we detail the particular technology, that is going to be out of date in about 6 months, and we would have been proved right. Interestingly, and this is my last point really, because I know I'm coming to the end. Interestingly, this is what I talked about the Judicial Roundtable. So that was essentially what we said about digital assets. We said, look, what we've done is extrapolated what's important about having a property right in something. Forget about tangibility. That doesn't matter. That's a red herring. It's been a red herring because historically we've always just accepted that the things we want to own are tangible. But it's not actually tangibility that's important. It's the other things I've mentioned. Independence, so it exists whether there's somebody to claim it or not. Rivalrousness, I know it's a great snappy word, but we really can't think of a better one. If I'm enjoying it, you can't enjoy it at the same time. So it's singularity of use, which again is important for commercial documents. No point in me modifying a bill of lading if someone else can modify it at the same time. So it's got 2 names on. What do we do? You know, that's very important. And divestibility on transfer. So just like passing over a piece of paper, if I pass you a piece of paper, I no longer have it. And now technologically, as I've said, we can do that with electronic paper. So what we basically said was, where a digital asset has these characteristics should be treated by the law as if it were a conventional thing. So we said this to the judges and we presented them with all the research that we'd done. And interestingly, they said, well, that's fine. And mostly we do agree with you. And we think we can do this and we think it's the right way to do it. But actually, we'd quite like a very short clarificatory act. Just saying that. Just saying, just because something is neither a thing in action or a thing in possession, so pure debt or horse, doesn't mean that it can, so it's deliberately negatively expressed, so it's as wide as possible. Just because something's not either a debt or a horse, thing in action or thing in possession, doesn't mean that it cannot be the object of property rights. So I can still have my NFT or my virtual currency coin protected. And so they asked for that. So we produced a bill, which is 2 clauses long, and well, we don't yet know. It's still going through the sausage maker. So who knows whether that will be on the statute books or not. I mean, personally, I don't think it's necessary. As I've said, I think the common law can do this. We've provided a report with guidance to the common law to do this. But I thought it was fascinating that the judges who are empowered to do this and who can do this, and certainly are obviously capable of doing this, said they would feel more comfortable. There had been a few cases before we got this project where judges were very close to saying you can possess a digital thing, but obviously felt that it was a big leap because these are, brand new things to talk about. And one of them in particular, I think twice it was actually referred, they said, we're very convinced by counsel's arguments, but essentially this is a big leap. We need Parliament to look at it. We need the Law Commission to look at it, which was great for me because it meant we got the project. But it was really interesting to me that they said, despite that, even with your suggestions, it would just be helpful. Of course, they didn't say it was necessary. They knew that they can do it. But they said it would be very helpful to have this clarificatory statute that they can point to and say, there you go. Parliament says it's okay. So watch this space in terms of the Digital Assets Bill. I mean, I don't think it's necessary, but I would really quite like it to pass, not least because I think it might then be the shortest statute on the books. And I'm all in favour of things being as short as possible. So on that note, I'm going to stop.
You have been listening to the University of East Anglia Law School podcast series. This special episode was presented by Professor Sarah Green, with music by Rishi Galati, Josh Harrison, and Hari Sharma.